Good afternoon, everyone. I am very excited to announce the launch of Americans for Tax Reform's newest project, the Open Competition Center. I am Katie McAuliffe, and I am Executive Director of Digital Liberty, one of the affiliate projects of Americans for Tax Reform. And I'm also Director of Federal Policy at Americans for Tax Reform. And I'll be your MC today as we go through some really interesting discussions on antitrust and how those affect the economy and business at large. But first, I'd like to introduce Tom Hebert, my colleague, who will be running the Open Competition Center.
Thanks, Katie, and thank you all for being here. I'm Tom Hebert, and I'm the Executive Director of the Open Competition Center, as well as the Federal Affairs Manager at Americans for Tax Reform. Our main focus of the new center is promoting a rule of law, consumer-based approach to antitrust regulation, as well as promoting open competition among labor and at the ballot box. We believe that antitrust law should be focused on maximizing consumer welfare and protecting the competitive process, not protecting individual competitors in the marketplace. The consumer welfare standard has been the North Star of antitrust policy for 4 decades. We believe that upholding the standard is crucial to protecting American innovation and entrepreneurship. We will oppose those who would weaponize antitrust law to address broad, unrelated social concerns or break up successful companies just because of their size. We believe that an activist, overly broad approach to antitrust enforcement will harm consumers and stifle innovation. Such an approach would give unelected bureaucrats the power to reshape the entire U.S. economy, something conservatives should strenuously oppose. Today, we'll have an engaging conversation about antitrust law, as well as the landscape under the new administration and the Democrat-led Congress. We'll also talk about how undermining the consumer welfare standard will harm small businesses and discourage innovation. Feel free to keep up with our work by visiting opencompetitioncenter.org. With that, I'll turn it back to Katie.
Great, Tom. Really excited to be working with you going forward on all of these issues. Next up, we have what I'm very excited to hear, a fireside chat with Americans for Tax Reform President Grover Norquist and Federal Trade Commission Commissioner Noah Phillips. So without further ado, here we go.
Hi, Grover Norquist here, Commissioner Phillips. As we look at today's questions about what we're doing with, for, and to antitrust law and actions, could you give us some perspective? When did antitrust come about, the Sherman Act, the Clayton Act, and what were people responding to? What did they think the problem was? How did things work out? And what's the trajectory sort of from when it started to where we are now?
Thanks, Grover. And let me begin first by thanking you for having me, and also with a caveat that people in my position have to give, which is my remarks are just my own. They don't necessarily reflect the position of my colleagues or the commission. The antitrust laws in the United States were first passed in 1890 with the Sherman Act. And that's a really interesting time in history for us to study because a number of different things are going on. Some of which find analogs today, some of which are quite different. The nation is, after the Civil War, it is a period of tremendous industrial change, innovation, growth, but also social disruption, right? People are moving into factories. Production is changing where people live. It's changing how people live. And one of the things that is going on at the same time, and is not unrelated, is that the prevailing wisdom in the market among business people is that the best way to organize is in what we would now call like either a monopoly or a cartel. They believe it is more efficient to have centralized authority in a given industry. And so you see actors like JP Morgan, who is a banker, right, organizing trusts. We don't really have corporate law as we know it yet, but what we see in the US and abroad, because this is not just limited to the US, is the sugar trust, the cotton trust, the oil trust, railroad trust, and so on and so forth. So this is what's going on in the country. It is very disruptive. It is very good in many regards. It sort of undergirds a lot of how we live today and a lot of the benefits that we enjoy as consumers and otherwise. But it also puts a lot of folks out of business. Right? It upsets the apple cart for a lot of incumbent businesses, a lot of small businesses too. And there's just social change. And with social change comes people being upset. And one of the things that are targeted, to some extent for the right reasons, to some extent for the wrong reasons, are these large trusts. And that is the circumstance under which the US arrives at the Sherman Antitrust Act. It's not the first law. There's a common law of monopoly that exists. There are several state statutes, but this is the first federal law.
Okay. But what exactly is a trust? A collection of independent companies that become a trust how?
So this is a little bit the arcana of what was the pre-existing corporate law, but you basically set up, you bring together a bunch of companies and they have interlocking directorates and, I sit on your board and you sit on mine and they make decisions together. This is simplifying a little bit the history, but basically we would recognize this today as a cartel. It's important to note that at the time, state corporate laws don't allow holding companies to own corporations across states. So for example, in the case of Standard Oil, you have to find another way to organize.
Oh, so you can't have a New York incorporated company doing business everywhere else?
No, not in the way that we understand that today.
Okay. So then did the trust become disentangled as a result of antitrust law?
So some of them did. And then there were other developments that went on in the economy that sort of changed how things look, including, as I alluded to a moment ago, developments in corporate law.
And, okay, you had trusts, the antitrust people showed up and they went after who? And give an example of what dissolved the trust or...
They went after a number of different trusts, but the most famous example is the Rockefeller Oil Trust, Standard Oil. So Standard Oil, begins as a sort of trader and refiner, and it expands into exploration and production, and it serially acquires a bunch of companies that are producing oil, that are refining oil, and still today, the standard barrel of oil by which we measure, the assets of a Chevron or the assets of an ExxonMobil is the size of the barrel that John D. Rockefeller conceptualized and marketed.
Okay, so when it was broken up, what happened?
So this is a really interesting story. A lot of the same talk that you're hearing today, it was a big and powerful corporation, it was preventing others from competing, led the government to bring this big case. And the background is important, but the outcome is even more interesting. The background is that Ohio broke up the trust. It was an Ohio trust. And then the parts gathered together again in a corporate form in New Jersey, And that's why Exxon was the Standard Oil of New Jersey. But right after the government breaks up the trust, what happens? The people who ran the trust still control a bunch of effectively local monopolies. The Standard Oil of Ohio, the Standard Oil of California, the Standard Oil of New York, the Standard Oil of New Jersey, Exxon, Mobil, Chevron, Amoco, and so forth. These are names that we still recognize today. The price of oil went up, not down. It went up. And you had the same level of sort of these kind of cartoonish villains controlling the same amount of economic power. Interestingly, one of the first things that my agency, the FTC, was charged with doing was exploring why are oil prices going up?
Okay. And did they come to a decision? Is that what you just, that as to why prices went up after the Standard Oil was broken into different pieces?
Well, so one of the things that we have learned in subsequent years is part of it is the government had eliminated a very efficient producer and distributor of the product.
Okay. So then how does antitrust law move through the years when they seem to be going after companies just because they were big in the 60s or 70s, and then Bork and others were rethinking antitrust into the 80s? Can you take us into the 50s and 60s after World War II?
So antitrust sort of takes a break for the Depression and the New Deal in World War II. And we come out in the 1950s with a very aggressive program of antitrust enforcement. The government goes after GM. The government goes after IBM. Lots of different companies that you can name were the targets of antitrust scrutiny.
What was the reason given for GM or IBM? Why was that invoked?
I think whether the manufacture of distribution of automobiles or mainframe computers, the view was that these were insuperable monopolists. They were large, they were ubiquitous, and certainly, right, their business practices were hurting other businesses because they were, to some extent, outcompeting them in the market. And so you get to a point, and this really happens in the late 70s, where people start to look at three different things. The first thing is that America is not considered terrifically competitive as a nation. We're spending a lot of time over-regulating and over-enforcing against our own companies. And there are questions asked why that is so. And antitrust is not the only, but it's one of the culprits. The second thing is that people are noticing, including the courts, that there isn't a lot of coherence to the law. There's, in fact, the famous quip by a Supreme Court justice that the only consistency that he can see in antitrust is that the government always wins. If it's high prices, right, it's clear indicia of market power. If it's low prices, it's predatory pricing. Pick your devil. The only coherent rule is that the government always wins. But the other thing that happens at this point is that a group of scholars begin to sort of look at the intellectual underpinnings for how antitrust enforcement is done. We call this SCP, structure, conduct, performance. And it basically reduces to the notion that the fewer numerically competitors you have, the higher prices you will have, the lowest quality, the less innovation, and so forth. And what these folks realize is that those intellectual underpinnings just aren't there. It isn't necessarily true that if you have 7 as opposed to 3, you're going to have better outcomes for consumers. And out of that, there's sort of the Chicago school and the Harvard school, but out of this rises the consumer welfare standard. The notion that you are looking to try to improve the lot of people, the people who go to the grocery store every day, the people who pull their cars up at the pump, who may not care as much from whom they're buying, whether it's a large or a small business, but have a great interest in better quality, more innovation, and critically, lower prices.
I remember with the Incredible Bread Machine, the poem that if you charge too much, it's gouging. If you charge more than everybody else, it's gouging. If you charge less than everybody else, it's predatory pricing. If you charge the same amount as everyone else, it's collusion. And either way, they're going to get you. So was it one Supreme Court decision which said, here's what it is? Was it a series of them? Was it the FTC restating what they're doing? Was there a law that moved it more in this direction?
I think above all, it's a story of learning going on in the academy and a series of Supreme Court decisions and lower court decisions to some extent that looked at practices that were generally considered illegal, recognized the fact that the results of those practices weren't always bad, and in fact, more often were good, and began to subject each case for these kinds of practices to greater scrutiny. It wasn't just the government got to go into court, allege the thing, and you were done. You'd have to show that it had a bad effect. And if there's any sort of big important lesson to glean from what happened is we moved from a series of judicially created and intellectually ill-supported rules barring conduct to an area where we would look at what was happening. To be clear, there are vertical restraints that can be bad. There are mergers that can be bad. But the question isn't just simply looking at the category, it's what are the facts on the ground? What's going on in every particular case?
What was the case in the 80s that Reagan dropped? Was that AT&T or IBM?
So Reagan famously dropped the IBM case when he came into office. That was a case that had been initiated under the Johnson administration. Many fortunes were built of lawyers on that case. To some extent, modern civil litigation, where you give a lot of documents to the other side, that was built on that case. It didn't come to a lot. And then, of course, now mainframe computing is just not how we do things.
Okay. I had a friend who was planning on spending the rest of his life on that case and was disappointed when the law firm had to lay everybody off.
So I will tell you, I began my legal career at that law firm, Cravath, Swaine and Moore. And, people were buying homes in Westchester because that's where the courthouse was. It was in White Plains, New York. There's a whole history to that particular litigation, which again is basically 14 years and results in zero.
I remember when I was a kid thinking, in the United States, the government sues successful companies, and in France and England and Germany and Japan, they subsidize them and view them as part of the nation's structure. That they like big companies that seem to be successful.
I once had a European general counsel come up to me at an event, and he was like, "I know why we're targeting you guys, but why are you?" And to be clear, Grover, I don't think anybody takes the view that successful U.S. companies should be inoculated from liability. Heavens, no. When they break the law, we should go after them. The question is whether you take as particular targets or you sort of innovate law to go after things that are really fundamentally good.
Okay. How much is this an American phenomenon? Did we invent antitrust? Did we borrow it from somebody in Switzerland someday? And has the rest of the world moved towards the consumer harm thinking as the U.S. did?
So the answer to the last question is, in general, in the world, we have moved toward focusing on consumer welfare because we've been seeking a coherent rule that produces good effects for consumers, right? Everybody wants to benefit consumers, or at least most people do so. In terms of the particular origins of the common law, I think they have their roots in England, like much of American common law. I don't know to what extent that maps into sort of civil law countries, let's say, in Europe.
Okay, so the common law would be what? You can't have a monopoly?
Not so much you can't have a monopoly, but prescriptions against price fixing, this sort of thing.
Okay.
Historically, by the way, the biggest concerns about monopolies, like if you read the documents of the founders, they were very focused on the law against monopolies in England, was what you used to have were letters patent issued by the king. So the king would say, I want to invite your business, you are an Italian glassmaker and I want you in London because we've got these windows and they're not pretty. And what you have in Florence is pretty. I'm going to give you a monopoly, like a court government chartered monopoly, right? The East India Company is another famous court chartered monopoly. It's interesting today to see the same people who purport to be aggressive against monopolies in American politics support government licensure of corporations. But this is exactly what was going on in the 17th and the 16th century, and it was viewed as bad. The American founders did, of course, is they said, sure, you can grant them monopolies to promote science and the useful arts. That's patent and copyright and so forth. But outside of that, no, you don't just get to be the friend of the king and then you get to own the industry. We're going to allow competition outside of it.
Patents give you a monopoly for a certain number of years. Were these grants from the king indefinite, or were they also given for a certain number of years? Did each company have a termination date?
I don't know the answer to that, and it may have varied, but they were called letters patent, and that's the origin of that word.
Oh, okay. So patents come from the grant of a monopoly. Okay.
Correct.
That makes sense. What is the most successful antitrust case where advocates of antitrust would say, see, that was a real good one, that really worked, that did what we wanted?
I think there are a lot of great instances to look at, some going back some time. I mean, people differ on this. I tend to think that the breakup of AT&T was a successful breakup. Mm-hmm. The Microsoft case, a lot of people look to. Those are two in the tech space. There are obviously some outside it. And then there were some with a less good effect. There's famously the Vons grocery case where there are grocers merging in LA and they're getting to 6% share together. And it's just almost impossible to think of how that would be a problem for competition.
Mm-hmm. Now, there's a discussion now about rethinking antitrust. Some people who are unhappy with some of the major platforms, Apple, Facebook, Google, and because they don't like their view is that they censor what people say or tell the president he can't be on Twitter, that they would like to use antitrust to somehow do something. And I'm at a little bit of a loss as to, are we just punching them, or are you trying to break it, the way they cut a diamond, or you're trying to do something and then you get a better thing at the end of the day? I'm not hearing an articulation of how sicking antitrust on Google would give you the diamond instead of a pit bull grabbing somebody by the leg. Or why would that make them not censor things?
So I think part of what's going on in American politics today is that people like the language of monopoly and the remedy of breakup to express sort of profound dissatisfaction with something they don't like. Maybe it's censorship. Maybe it's privacy violations. Maybe it's a failure adequately to distribute the gains of the firm to labor. Right? You hear a lot of different arguments about how antitrust can be used. My view of the question is there are times when competition can yield other results, but fundamentally these laws are designed to protect competition, and they can be used effectively to stop problems that inhibit competition, like when people are price fixing. But the more you try to aim the law at other problems, and certainly if you try to use the law as sort of some sort of general government cudgel against something you don't like, I think the more you undermine the rule of law. It's also unclear to me that the ties are necessarily there. So I'll take the bias example. Of what is Twitter a monopoly? Twitter is a big company. It's ubiquitous. They have a certain power. There's no doubt. And to be clear, I suppose I could be presented with a set of facts, but it's difficult to think of what is the market of which they are the monopoly. And to be clear, there are content moderation questions for firms that are small, and there are content moderation questions for firms that are large. Substack, Reddit, Gab, all of these are smaller players, and people have different views. And by the way, when we're talking about something that is necessarily subjective in nature, and one group of consumers thinks what you're doing is wrong with the moderation decisions, and the other group of consumers think it's right or not enough, finding it as evidence of market power is a lot harder. And of course, that leaves aside a lot of important First Amendment.
When some folks have been suggesting changing away from the consumer benefit or consumer harm to some other mechanism. It's big, we don't like it. I'm not sure exactly what the lines they're drawing. Would this be done just for the 4 or 5 high-tech social media platforms, or are the changes in laws being discussed also ones that would affect the auto industry and the steel industry and farming and other industries? Is there, people talk about it as tech specific, but the changes in law that I think I'm seeing would affect everyone.
A lot of the major proposals are not at all limited to tech. So for example, there was a big report put out by the staff of the House Judiciary Committee last year, following a long series of hearings and an inquiry really focused on big tech. And they called the executives to some of the large big tech companies, not all of them. But the proposals, you're right, go far beyond that. They're not at all limited to tech. There are proposals to redo how we think about antitrust, how we think about a lot of things even beyond antitrust, for the entire economy.
Okay, so the Patriot Act changed the law not just for terrorists, but for everybody. And the first prosecution was somebody ran a strip club in Las Vegas. So the whole thing was sold as we're going to have all these powers. They're going to go after terrorists. And then it turns out they could go after you on other issues, but with new and enhanced powers. Is there a discussion in the business community about, if I was standing over to the side and watching people throw rocks at big tech, and then they announced that they're now in favor of throwing rocks and at anybody, I would be nervous and would be out talking. I'm not hearing other industries sound scared the way the tech companies realize they're kind of in the crosshairs. But as you were pointing out, everybody's potentially in the crosshairs if some of these changes would be enacted.
Yeah, I mean, when you're making generalized laws, they're going to apply generally. I don't think that there is any industry that we should inoculate from the antitrust laws. Now, there's a really interesting back and forth that goes on in the agencies and the courts where you have a lot of regulation and people are complying with regulation, but the outcomes are anti-competitive. But where you're talking about generalized laws, I think this conversation needs to be had much more broadly than tech, because we're not just talking about tech.
What is the exemption that the football and baseball seem to get? What do other companies or businesses and industries come in and say, could we have an exemption?
Yeah, I think there's actually a proposal right now. I don't know if it's been reintroduced in this Congress, but there's a proposal to allow media companies to, to bargain as a group.
And not be subject to antitrust law?
Yeah, I haven't familiarized myself with the text. I'm not sure that the new version is out, so I'm not sure what the metes and bounds are. But my sense from sort of press reporting is that's the gist of the proposal.
Okay. Well, we're coming up on the half hour, but what is happening is in the FTC? What have you been doing in this competitiveness zone? I mean, separate from antitrust law, but efforts to increase competition or reduce barriers to competition. What were the last several years of the FTC's work?
I mean, the last several years have been pretty aggressive, mostly on a bipartisan basis. We've brought really important cases in consumer products. We've brought cases in hospitals. We've brought cases in healthcare. Some of these are a lot of these are merger cases. Some of these are conduct cases, right? Section 2 monopolization cases in electronic health records. And in preventing drugs from getting to market, this sort of thing. So there's a lot of work going on. The agencies are voting out case after case after case. What's important to me, like I want to protect competition, is that we do it in a way that is coherent and that we do it in a way that is fair.
How many antitrust cases are going on at any given time? 500?
It's not 500, but it's not 5. I don't know the exact number as I sit here in litigation, but it's well more than 5. And a lot of these things don't end up in litigation. Sometimes where we see a problem, we'll settle with the company, right? Reach a consent that resolves it. You've got these 2 overlapping gas stations, but the rest are okay. You just sell those off. Sometimes what you'll see is we'll bring a case and the deal will be pulled off. Companies won't want to consummate the merger. We brought a case against a company called Illumina, which does gene sequencing. They wanted to buy a rising competitor, PacBio, we alleged. We sued and they called off the deal. So that happens too. But there's definitely a lot of litigation going on as well. Okay.
And at the FTC, how much does this slow down mergers and acquisitions? Is there something that could be done to speed up getting the green light, or I want to merge? Do I have to come and ask permission, or 2 companies, Mother, may I? Or do you look around and when you see one that looks too big or something, say, we'd like to study you for 2 weeks, 2 years? So
generally speaking, deals of a certain size have to be noticed to the agencies, and then the agencies have the option to initiate a broader investigation if they're concerned. That can take a lot of time, but that's a better way to do it than we used to. From 1890 to 1976, the government would go in after the fact and try to, the term is unscramble the egg. They try to bust up the company. We still do that occasionally, right? We still occasionally, a merger isn't noticed to us or it proves more problematic and we try to undo it. But in general, what we're doing is ex ante, right? Before the thing, merger control. One thing that I am concerned about, and we're beginning to see a little bit of this lately, is attempts to sort of slow the roll of all M&A across the board, whether we see a competitive problem or not. So there was a proposal last summer in Congress to just ban all M&A. And to be clear, I don't just mean mergers. I mean, executives converting their stock, index funds who are trying to keep the basket of assets that they need to track the market, this kind of thing. Stop at all. And more recently, we canceled something called early termination. So companies that don't present a problem, where we're not interested in them, used to be able to come to us and say, hey, can you just let this go? I've got a timing problem. And now, for the most part, we're not letting that happen. To be clear, this is for transactions that no one thinks have a competitive issue.
Okay, well, Commissioner Phillips, thank you very much. We're going to be trying to focus on maintaining as much competition as we can, having the government with a light hand, but to make sure that barriers to competition are knocked down and that people don't try and use antitrust or antitrust law to fix any number of problems that have nothing to do with competition. But we seem to have, I don't like big tech and their censorship policies, therefore, and I get confused sometimes about what the fix to that is that has anything to do with antitrust, other than it seems to be a way to get somebody's attention to threaten them with antitrust. Katie, can we go back to you and continue the show?
Thanks for having me, Grover.
Absolutely. Thank you, Commissioner.
Thank you both so much for joining us. And if I could just take a little privilege and ask one last question, because right now we do have an antitrust hearing going on while we're talking about this. And regardless of what goes on in the House, the Senate, what direction do you see the FTC going forward? Like, how do you think the FTC is going to operate? Are we going to see more rulemakings? Any kind of reading of the tea leaves that you might have there?
Well, let me say the following. My Democratic colleagues have taken the opportunity in a number of cases over the last few years to lay out in dissents what they hope the program will be, with varying degrees of clarity. I think you'll see attempts at rulemaking. I think you'll see more objection to various aspects of mergers. And to be clear, my view is the agency has been pretty aggressive already. We're not winning every case that we bring. We just unfortunately lost what I thought was a really good case, blocking a hospital merger in Philadelphia a couple weeks ago. I think you'll see more litigation. Whether it results in benefits to consumers, whether we're focusing on the worst of things, the things that are going to be bad, that remains to be seen.
Great. Well, thank you again both so much for your time. I'm going to let you guys go. Really appreciate it. And we're going to bring Tom back up and move into our next panel. Thanks so much.
Thanks again. Bye-bye.
Great. Thank you guys so much for listening to that conversation. We're really excited to have both Grover and Commissioner Phillips with us for that discussion. And I'm bringing back up Tom, and we are going to move into our panel discussion with an esteemed group of experts. I mean, we definitely know a lot about the small business realm and antitrust, and really can take a practical approach to this, right, Tom?
Absolutely, yeah. I think one of the main goals of the Open Competition Center is to connect some of these loftier academic concepts with the real world and really demonstrate that what I like to call the trickle-down damage that a more interventionist antitrust approach would have on small businesses and the economy at large. With that being said, I'm very proud to introduce this panel. We have with us Sam Bowman, who's the Director of Competition Policy at the International Center for Law and Economics. Sam is the former Executive Director of the Adam Smith Institute in London and the current Principal at Fingleton Associates. Along with his expertise in economics and policy analysis, Sam has proven success in nonprofit leadership, program development, coalition building, and stakeholder engagement. Welcome, Sam. We also have Kerrigan, who is the president and CEO of the Small Business and Entrepreneurship Council, a national advocacy, research, and education organization dedicated to protecting small business and promoting entrepreneurship. For more than 25 years, SBE Council has led a range of policy and private sector initiatives to strengthen the climate for strong startup activity and small business growth. She also chairs the Small Business Roundtable. Welcome, Karen. Thanks for being with us. And finally, we have Valerie Gatos, who is currently serving her second term as a Pennsylvania state representative from Western Pennsylvania. Prior to serving in the State House, Valerie was an entrepreneur who started and ran her own company, Capital Growth Inc., an information publishing company she founded in 1994. Over the last 25 years, Valerie went on to invest in other startup companies, including one that sold to Intel, and later guided other entrepreneurs as president of the Pennsylvania Angel Network and the director of the Pennsylvania Private Investors Network. She is currently an angel investor with Hivers and Strivers, an angel investment group which invests in veteran-owned tech startups. Welcome, Valerie. Thank you all for being here. As a reminder, you can comment in the YouTube comment section, and we'll address your questions. But I think we'll kick it off with Sam. Sam, can you give us a sense of what the history of the consumer welfare standard is, and then some of the recent attacks on the standard, both from a legislative perspective and from an activist perspective?
Absolutely. And thank you so much, Tom, for inviting me to speak, and congratulations. I'm really excited to see the work you guys get up to here. So I want to talk about, why should people care about today's antitrust debates? And the first reason is, if you're a conservative, it's because American antitrust is one of the biggest conservative successes in the past half century. It's often interpreted as being a success of less enforcement, and I think that's a mistake. Instead, I think the conservative antitrust revolution that took place in the 1980s and 1990s, and we're still kind of living through, was about focusing antitrust on an objective standard. And the standards that it ended up focusing on was that of consumer welfare, which says that when we're trying to weigh up all of the effects of a business merger or of other business conduct, the ultimate question that we always bring it back to, that we always have to answer, is how does this affect consumers in the long run and in the short run? We're not just thinking about price, we're thinking about things like innovation and quality and choice as well. Before the focus on the consumer welfare standard, as Commissioner Phillips was just saying, antitrust was about everything. Antitrust had to weigh up things like the environment, had to weigh up things like the effect on unions, had to weigh up the effects like on competitors. And what that meant was, because it's impossible to measure up those different things, antitrust was often incoherent and unpredictable, which made it very difficult for businesses to plan around. And it also meant that individual courts had a huge amount of discretion about what the law actually meant. Individual courts, because they had no objective standard, could say, I think that actually the effect on labor unions does mean that higher prices are tolerable. I think that, in fact, it doesn't matter that this merger would be pro-competitive or pro-efficiency, because I don't think that the impact on the environment is worth it. And that meant that antitrust was very incoherent, and I would say not compatible with the rule of law, because it wasn't predictable. By focusing it on the consumer welfare standard, it meant that we could bring economics and economic evidence to bear, so that both sides could have an objective standard that they could argue in a court of law and say, according to this objective standard, we think our argument wins. There are people like Herbert Hovenkamp, even Fiona Scott Morton, who are considered to be on the kind of center left of the antitrust debates and think that we should have much more enforcement, think that the federal antitrust agencies should bring many more cases. But they're also believers in the consumer welfare standard, because they realize, and I think this is the really key point, that the consumer welfare standard is about objectivity and evidence. It's not about more or less enforcement. There's room for everybody within this approach. So that's why I think the current proposals that are going through the House and the Senate really, really matter, and they worry me. Both Democrats and some Republicans seem to think that we should move away from this standard that prioritizes consumer welfare and prioritizes competition, and instead we should reintroduce the kind of old way of doing things, where antitrust is about pretty much solving every social problem. I think that what that means is that antitrust will become incoherent again, because often the welfare of competitors, for example, in Senator Klobuchar's bill to reform antitrust, she wants to replace the focus on consumer welfare with the focus on competitor welfare. Often what that means, though, is that business conduct that is pro-competitive, like cutting your prices, could be condemned and rendered illegal because that's harmful for your competitors. But that's the point of competition. Competition should be harmful for your competitors, as long as it's fair, as long as it's not preventing them from competing on equal terms. You should be trying to make your competitors' lives difficult. That's what competition is about. An absence of competition is associated with an easy life for businesses. I don't think that that's what we should want, and I very much worry about any kind of approach that would get us back to that kind of situation. And I think that matters a lot, because whether or not you're deep in the weeds of the antitrust debates, anybody watching this, I think, cares about the dynamism of the American economy. And as somebody who's not an American, I have a huge amount of admiration for the amount of entrepreneurship, business formation, growth that takes place in America, and really, I think, filters down to the rest of the world. In many ways, I think of America as the kind of laboratory of ideas, especially business ideas, for the whole world. And I think in large part, that's because the American economy is so much about risk-taking. It's so much about people putting all of their ideas and all of their money and savings into their big idea, because they know that if they're successful, they'll get great rewards from that. And they'll be able to run a great business. They'll be able to live a really, really successful life. And that does mean that American markets are more sharp-elbowed. In the European system, competition law says that there are special rules that govern big companies, even if they've acquired their size through completely legitimate, completely legal means. There are still rules that say, you can't do this, you can't raise your prices here, you can't make this much money because, it's not fair on your competitors. I think that's a real mistake. And I think that's one reason that the European economy has lagged so far behind the American economy for such a long time. So I'm really concerned when I hear people like Senator Hawley, who is just in the Senate now, proposing that America adopt European standards, adopt the principle of the abuse of dominance. Because I think that not only would that bring America back to the kind of bad old days of incoherent antitrust, where courts get to decide pretty much for themselves what the law says, it would also, I think, sacrifice a lot of what makes the American economy really good. I don't think that this means that we have to say that businesses can always do whatever they want. I think there's a really important role for antitrust in maintaining competition and in setting out the rules of the game in such a way that businesses can compete on equal and fair grounds. But I do think that, and in fact, I think that when there are concerns, for example, about freedom of speech, there's a role for Congress. There's a role for actual politicians to do politics and decide what they think the rules of the game should be. The danger is changing the rules so that courts get to decide the rules of the game, do so in an incoherent way, and do so in a way that prioritizes business welfare over consumer welfare, and ultimately sacrifices competition for, I think, a misguided view of how markets should work that focuses really on insulating businesses from competition when we should be trying to strengthen it. Thank you.
Absolutely. Thank you, Sam. And speaking about businesses and small business, I want to bring you in, Karen. There's been a lot of discussion about using antitrust law to break up big tech. And I really wanted you to highlight especially in the past year during the pandemic, just how vital the tools that these platforms offer are to small businesses, and kind of what environment should we be cultivating to be conducive to small business growth. So take it away.
Great. Thank you, Tom. And congratulations, to the center. We look forward to collaborating with you. It's really needed right now, this voice, and certainly the members and entrepreneurs who belong to SBE Council appreciate your leadership in this regard. Well, let me just start by saying, big tech began as small tech, as tiny little businesses. And, this type of entrepreneurial spirit and risk-taking and innovative leadership that brought us big tech is what our government needs to be celebrating and encouraging, not undermining through intrusive policies or actions that are threatened and that are quite reckless. Because in the end, it will disrupt America's fertile and dynamic startup ecosystem, which has been the envy of the world, as Sam pointed out. But unfortunately, it does seem that some in government, some elected officials are quite bent on sort of joining the work of our global competitors in destroying some of America's best technology companies. And by extension, this will really harm the ecosystem that enables a startup activity, investment, economic growth, all those productive things. So it's a real head scratcher to me and our small business members that there seems to be a doubling down and a continued focus on these antitrust efforts and actions during a period of time when we need all businesses across all sectors, all sizes, small, medium, and large, to survive, to innovate, and to succeed. And there is no doubt that without technology and the various platforms that exist today, startup activity and business formation would be far lower and weaker than it was prior to the pandemic. And certainly without these tools to turn to during the shutdown, the COVID-19 economy, small business closure, the economic devastation would have been much higher. The massive shift to everything online as a result of the pandemic pushed and allowed many small businesses to continue operating and to drive revenues. We did a June 2020 small business technology survey with Technometrica, which revealed just how important tech tools, online tools have become to small business survival. 76% reported that platforms, cloud services were critical to the survival and operation of their business during COVID-19. 79% agreed that these tools have helped their business more effectively communicate with customers and potential customers and better manage their customers during COVID-19. And it also had an impact on the productivity and the morale of their employees, as 84% said that the full suite of various technology platforms improve employee productivity and collaboration. So, and it was very early on in COVID-19 that we saw many small businesses making this shift. Obviously, they were forced to because that's what was happening, right? And a May 2020 State of Small Business report that was put out by the Small Business Roundtable that I chair found that 51% of small businesses increased their online interactions with customers. 36% of personal businesses using online tools said they were conducting all their sales online, and 35% expanded the use of digital payments. So the bottom line is that technology platforms, the digital tools, they've helped small businesses pivot to new models, new products and services that help them run their businesses virtually, market and sell their goods and services to much larger audiences at low cost, and better communicate with customers and fulfill their orders. And, you know, it's the size and scale of some of these technology platforms and the massive number of people they touch. Again, these are potential customers, right? That helps small businesses reach those customers where they are and in substantial numbers, and that is online. So, you know, in thinking about moving forward about the state of entrepreneurship and startups and competitions on this day that the Open Competition Center launches, the good news is that the competitive spirit and the entrepreneurial spirit is alive and well. And that will continue to be the case unless, you know, the government does unwarranted harm to dampen that spirit and to undermine the ecosystem. You know, incredibly, during 2020, in the midst of a pandemic, expectations were smashed for new business applications. They totaled 4.5 million, which was 24.3% higher than in 2019. And for those claiming that retail is dead, that the big guys are crushing the aspirations and competitiveness of small retail entrepreneurs, that simply is not the case, because business applications in the retail sector actually saw the biggest 2019 to 2020 jump in new applications, 54%. And so non-retail trade applications, online and direct-to-consumer retailers increased 77%. So individuals and entrepreneurs, they're seeing the opportunity in the marketplace. Customers are online and in record numbers. They're looking for new and niche brands, and the availability of affordable and effective online advertising, the social media connections, and other tech tools are allowing new brands and startups to reach customers affordably and effectively. Another September 2019 report that we did on the digital economy found that small businesses save nearly $163 billion annually due to the efficacy and effectiveness of online advertising produced by the tech platforms. So, 89% expressed confidence that their advertising dollars would yield results for their businesses, which is quite extraordinary. And that's, due to the targeting. And for startups, being able to effectively reach potential customers through online advertising, that played a big factor in starting their business. 80% of startup entrepreneurs cited this as one of the most important factors in moving forward to launch. So as we move forward, on the policy and the antitrust front, and for small businesses to fully survive through the other side of the pandemic, they will need to continue to tap into these tools and the platforms that help them better compete and generate more revenue. And of course, navigate what's still to come, because that's still uncertain. And the solutions they will largely turn to are provided by technology or found on technology platforms. Especially now, Tom, the value of these platforms must be maintained, and the market, the policies need to foster even more innovation and competition. And again, small businesses are helped by these platforms. They're not harmed by these platforms. And we're asking Congress, lawmakers, regulators, and policymakers at all levels to engage and talk to small business owners and to understand the unintended consequences of their actions, to listen to small business owners, not the competitors, who may be cheering on some of these actions. So with that, Tom, I'll turn it back to you. And again, look forward to our discussion and certainly look forward to working with you all in the days and months ahead.
Absolutely. Thank you so much, Karen. That was great data on small businesses. I'll turn it now to Valerie Gatos. You've got firsthand experience in mergers and acquisitions, startup, venture capital. A lot has been focused on restricting mergers and acquisitions with these recent antitrust proposals. How would that harm the economy at large, and what role do you think mergers and acquisitions play based on your firsthand experience in fostering this innovation that we want to protect? Oh, I believe you're muted.
Thank you so much for having me on this panel. I really appreciate it. And I think, Sam and Karen have it exactly right. We really need to foster innovation. And when you look at, and I'm going to take a couple steps back on what an angel investor does and how we make money. And that is that angel investors are usually the first folks into a small business. And we make money through exits. So for angel investors who typically put in, and it's usually a round of under $500,000, that we make money by exiting. And there's only three ways to exit, and that is through IPO, through mergers and acquisitions, through strategic partners. And or actually, what someone would say that there's actually a fourth way, and the fourth way is going bankrupt and closing down. But we don't like to consider that as an option. But if you look at going public, there's very few and far between companies go public. And if you look at it, was it 2020, there were 407 IPOs in the U.S. and the previous year there was about 200. And an all-time high, which was back in the 90s, was around 500 companies. That's nationwide. So the days of swinging for the fences and going IPO are just, they're limited, and it's typically, you've got to have a higher amount of revenue and have a bigger company in order to get that exit. And as we know, from startup to IPO, it takes a decade. It typically takes a decade. I know we had some periods in the 90s that companies went pretty quickly, but again, those days are over. So a lot of people will refer to Apple as the greatest innovator, and that's simply not true. They're the greatest aggregator. So, Fortune 500 companies and these big tech startups, or not startups, but big tech companies, they have been typically the companies that buy our companies. And, most of the exits are $30 or $40 million or less. And so if you're a $30-40 million company, going public is just not an option. So the next best thing is really mergers and acquisitions. I mean, we do strategic partners, but at the end of the day, innovation occurs when startup companies develop, grow, build, and then have an exit. And the exit is really M&As. And in fact, I'm going to just say a little bit about number of companies. So like Google bought Adscape for $23 million. They bought Blogger for $20 million. Ask bought Jeeves way back then, or Ask Jeeves bought LiveJournal for $25 million. So that's really the sweet spot that, we are working on to try to get these companies to exit. And so, my view is that, and most of my colleagues would share that the cure for bad government is not more government. And that's what we really challenge with as angel investors, is that that's really our only option. And in fact, what's interesting is another comment that was made is that most of the large companies know that they are not necessarily innovators, that they are aggregators, is that we know we aren't good at startups and new ideas. particularly in that stage between $0 to $20 million in value. But they will purchase the companies. And frankly, that's our only exit. So as an angel investor, putting more regulation and preventing these companies from purchasing smaller companies just closes down a pipeline of innovation. So, as they say that, you don't help someone, you don't help someone off the ground by lying down beside them. And, there are many other things that we can do to help foster innovation that competes with the big tech. And that's what we haven't been doing. So, for example, a couple years ago when there were the changes in the patent laws that actually made it really harder for small innovators to go through the patent system. So we put some roadblocks in those smaller companies early on. And so now we don't have a pipeline of companies that are challenging these bigger companies, and that's free market. The other thing too is that with the Affordable Care Act, and I'm going to kind of go, on this little side tangent on this, is that when the Affordable Care Act prohibited small companies to pool like-minded companies, whether it be life sciences, et cetera, they took a tool out of their toolbox for growth. So the problem isn't that we should stop these big tech companies from growing. What we need to be doing is fostering small, early stage companies to challenge those companies with innovation, and that's really the only way that our nation is going to succeed, is if we foster innovation. And those are some of the components to it. Discouraging angel investing by putting more burdens on. And not only just burdens in terms of a time frame, but also in terms of the cost of dealing with what these new rules are with these with the antitrust expansion, is just going to make it put more burdens on the smaller companies and quash them and keep them down.
Excellent. Yeah. Excellent. Yeah. Sam, you mentioned some of the recent antitrust proposals, and you talked about how international competition policy is sort of what they're modeled after. Can you give us a sense of what's going on overseas, where you are actually right now, and kind of go through some of the recent antitrust proposals and how they would harm competition?
Sure. So the biggest and most important one is the European Union's Digital Markets Act. And what that does is set out a code of conduct, which is effectively a list of do's and don'ts that requires what they call gatekeeper companies. So those are usually big platform companies. I think it's worth noting that they're exclusively American platform companies, and we can talk about that later on. I think there's a fairly important protectionist element to all this. But what it does is prohibit a lot of conduct that I think most people would consider to be, in many cases, pro-competitive and in many cases good for consumers, and require certain other kind of conduct. So to give you an example, it's quite controversial, and I'll tell you where I sit on the debate about whether platforms should be able to use data they've gathered on their platform to develop products to sell on that platform. So the most obvious example is Amazon selling things like Amazon Basics products on its marketplace in competition with third-party sellers. Now, you can see why, if you're a third-party seller, you would not like that. That is very, very difficult to compete with. That can undercut your margins. It can make it impossible to compete with if Amazon can produce these things more cheaply than you. The Digital Markets Act prohibits that kind of conduct. I take the opposing view. I tend to think that that kind of conduct, because it can find gaps in the market and because it can effectively find areas where it is possible to produce a product more cheaply than is being produced at the moment, and then producing that product for that more cheaply in that way is good for consumers and ultimately makes the platform better overall. Incidentally, in making the platform better, by giving consumers the expectation that, if you go to, let's say, Amazon's marketplace, but this is true of lots of other platforms as well, that you will be able to get, I don't know, really cheap batteries or really cheap, reliable USB cables. Not only is that good for you as a consumer, it also happens to be good for lots of other merchants because it increases people's trust and people's sense of reliability on that platform. There are loads of other types of conduct like that the Digital Markets Act prohibits or the Digital Markets Act requires, like interoperability, which is maybe something we can talk about later. The reason that I think it's misguided is that it assumes that the people drawing up the law know from without even looking at the specific cases of the conduct that the conduct is always wrong, or that it's wrong so often that it's never worth permitting, even in the cases where it's good. I think it's really, really, really difficult to say that we have enough evidence. I mean, I think it's basically impossible to say with any credibility that we know enough about that kind of conduct to say. I much prefer the American antitrust law-based approach, which says certainly conduct that forecloses your competitors without giving a benefit to consumers. So certainly conduct that stops competitors from being able to compete is illegal, assuming there's no benefit to consumers, in which case it becomes a bit more complicated. But we're not going to say, before we know about the conduct, that this is illegal. We're going to say we're going to look at it on a case-by-case basis with evidence. The only real, or one of the few exceptions to that, are cases of cartels, where in American law, they say we're not that interested in the consequences of the cartel because these are so often bad that we're just going to rule them illegal kind of by default. I think that treating loads of other business behavior as being equivalent to cartels is a big, big mistake. And ultimately, I think it's not a coincidence that this only affects American tech companies. And I think that it stems from a deep anxiety in Europe about the lack of European competitors to American tech firms. And I think that they're going about creating those competitors in completely the wrong way, rather than cut back American companies and rather than trying to make American companies worse in the hope that European companies will be able to fill the gap. I think they should be looking at different policy levers that actually really aren't to do with antitrust at all, to encourage the growth of European equivalents and encourage startups and the tech sector in Europe. But right now, they've got a sledgehammer, so everything looks like a nut. And I think that's pretty misguided. And I don't think it's going to do very much to help the European economy, and certainly not European consumers.
Yeah, great. Speaking of that square peg round hole problem, Karen, you've been messaging with conservatives for decades, and you've got a long experience as a small business advocate. There's been a chief concern on the right with big tech is content moderation. And they seem to think that antitrust law is a way to go after big tech companies and hurt them. Do you have any thoughts about how we could better message divorcing these speech concerns from the antitrust concern? Because it's not just going to stop with tech companies if we go down this path, right?
Well, I think that's the big concern. And I think Mr. Phillips, hit the nail on the head, in terms of how do you cordon off this potential antitrust activity to only technology companies, right? I mean, it's like the precedent that you would set for other sectors and other industries, I think is quite extraordinary. And then what that would mean for other industries and the economy, for competition overall, and for the future of the U.S. economy. So, we're doing our best to, punch through, and ask members to stop conflating, sort of what we see as political concerns with economic issues, and I think where we've been, making some headway really is the messenger, and that's getting more and more small businesses, entrepreneurs, speaking up and talking about the unintended consequences, not only to their business, during this horrible time where we need, to get back to full recovery and there's no certainty, sort of what's ahead, but also for the whole ecosystem. As Representative Gaydos pointed out, it's like there's a lot at stake here. And this ecosystem that we've developed, which allows startups, to really, when they're thinking, about that exit, and if you have so much uncertainty moving forward in terms of, well, gee, there'll be look backs, where, a company who bought, a company maybe will have to sort of, divest from that company, or if certain type of M&A activity is not allowed. So I think really, and this is where we're starting to pick our activity up, is engaging the voice of entrepreneurs and small businesses to hopefully the light bulb will begin to go off a little bit more, not only in terms of the impact on their firm, the community, the local economies, and the value of technology, but then also, again, this sort of broader long-term impact for global competitiveness.
Excellent. And Representative Gaydos, we've talked a little bit about the pandemic, but I wanted to get your sense as to how the pandemic has affected startup companies, how it's affected angel investing, and what you see as their chief
startup companies, how it's affected
normal.
Angel investing, and what you see as their chief challenge when move forward.
Well, I think in many respects, because we invest in small tech startup companies, there are some elements of technology that has been very, very strong. And so, the challenges for most companies right now is new technology investment. So new investment. So our existing portfolio of companies is actually pretty strong and they're doing well in the tech space. But right now we're seeing a lot of angel investors just saying, hey, wait a minute, the exits are so unsure right now. And of course, getting wind that there's going to make it tougher to for these big tech companies to acquire small companies. I think you're going to see angel investors hold back money, and the amount of investments that's going to go into innovate. And we all know that innovation in the free market is what's strong. And anything that we can do to develop companies that will be challenging these companies. I mean, you look back at what do they say? Like IBM said that who needs a computer, and if you didn't have the small startup in Microsoft challenging those companies, you wouldn't have that innovation. So that's really the challenge right now, is that you're seeing investors holding back.
Yeah, and Sam and all of you, we've got a new climate here in Washington. We've got a new administration that's starting to get its legs under it. We've got complete Democrat control of Congress, unfortunately. What are the biggest, and I guess I would ask all three of you this question because you're all in different areas of antitrust expertise. What do you see as the biggest challenges to innovation coming down the pike here in the next couple of years, and how specifically will it affect the areas that you focus on? So I guess we'll start with Sam.
Well, I think that if we're talking about innovation specifically, Valerie's been talking about the importance of acquisitions to startup formation, and I think that is really, really important. If we're looking at the antitrust lens in particular, there's pretty good and robust empirical evidence that what Valerie is saying is true when we look at an aggregate level. When we look at a state-by-state level, rules that make acquisitions more difficult lead to falls in venture capital investment. When you look at a global level, countries that make acquisitions more difficult see a reduction in investment in startups. So I think that the thing that I'm most concerned about from a kind of antitrust point of view is a misguided fear of what is called killer acquisitions. And killer acquisitions are this idea that incumbents buy new entrants with the intention of shutting them down because they don't want to face that competition. And this does actually happen sometimes in the pharma market. That's where the empirical evidence is. But the pharma market is a very unusual market because, for example, intellectual property, patent rights are so important. And if you have a patent for a drug and a new drug that is similar, but in terms of the patent law distinct, comes along, that could be quite a big threat to the kind of value. But even there, only 7% of the mergers that this paper looks at are kind of deemed as killer acquisitions. So it's important to kind of put in context about this is quite a small proportion of mergers in pharma, and pharma I don't think is necessarily reflective of tech. Why? Because even if I, as a big evil tech company, buy this startup that's coming along with a really killer idea and I shut it down, there's very little to stop another company from coming along, copying that idea and doing exactly the same thing. And I can't just buy every single startup. I mean, if I did, that would be a kind of massive redistribution scheme to entrepreneurs, which would be great. I have to say that other than antitrust, what I'm worried about is a kind of precautionary approach to regulation of new technology. So things like gene editing, where I'm really optimistic about the capacity that we have to abolish a lot of diseases and to allow people to overcome a lot of inherited diseases that we could never have dreamed of even a few years ago. And I'm really optimistic about our ability to do that. And I fear that regulators may put kind of excess caution, and I think the FDA in particular has really shown bad form in this, in kind of overweighting the costs of new developments in areas like this and underweighting the benefits. So that's a separate point to antitrust, but I actually think that we should think about competition in a very broad way. I think antitrust is like putting people in jail, and it's really important to put people in jail, but there comes a point where there are no more people you need to put in jail, and there are lots of other levers in the world that you use to make the world better. And I think competition should be thought of not just as about the enforcement mechanisms, but also things like regulation of new industries, things like support for entrepreneurs, things like making sure that there's a business climate where pension funds, for example, can invest in venture capital. All those things I think should be thought of as a sort of broad kind of area of competition and innovation, in which antitrust is a really important tool, but not the only tool. So that's why I've kind of given both an antitrust and a non-antitrust answer to your question, because I think they both matter a lot.
I agree with Sam. I think it's, antitrust certainly is incredibly important, particularly, focused on an industry, our most competitive and innovative industry. Certainly it's the pharmaceutical industry. And the impact that, obviously this activity would have on investment, but there's other regulation going on too that we're very concerned about. Obviously, any uptick or changes, for example, in financial market regulation and what might happen at the SEC, the impact on capital formation and capital access for small businesses and startups, mid-sized businesses. Extremely concerned about that, because capital is the fuels innovation. I mean, there's no doubt about that, and all this really positive activity, that we see happening in the ecosystem, whether it's starting up or M&A activity, or just innovation within the big companies themselves, and how much capital are they going to be putting into innovation if there's this much uncertainty going on with respect to antitrust and regulation in general. And of course, we're very concerned also about labor markets and labor cost and the impact of any higher costs on labor. We saw the PRO Act that passed the House. We don't think it's going to pass the Senate. But when you begin to constrain the independent contractor model and make everyone become employers, then essentially you're just undermining the entire startup ecosystem. And so that human capital is also so important to innovation, whether it's raising the cost of human capital for the best and the brightest to go to firms so they can get better, or it's individuals wanting to start their own business but being constrained because they can't do that because of independent contractor laws. So those are just the tip of the iceberg thoughts that I have, Tom. Obviously, taxation and specific regulation I'm concerned about, and of course, activity at the state level. But we do seem to be going in a different direction than we were over the past couple of years, and that's really going to harm, I think, some of this momentum that we had going into the pandemic. But also a lot of this positivity that people had either out of necessity or out of opportunity in starting those businesses and seeing those off the chart startup activity numbers that we saw.
Let me add that, I always say that sometimes government, and of course now after spending 25 years in the private sector, this is my second term as a state house member, and I often say that, it's government always tries to fix things that they made a mess of in the first place. And so I'm a strong believer in the free market. Free market fixes a lot of things. it shouldn't be unlimited. I mean, I get, why we do need some antitrust rules to try to keep the four corners of the page and the playing field of which we are on. But I always say that, the analogy is that let's say there's two folks playing basketball, and I'm afraid that my competitor is taller than I am. And the solution is, let's put the basketball hoop higher. And the answer is no, we don't want to put it higher. Leave it where it is, or even lower it, so that I can actually then jump and make that hoop. And that's really what I think that, we really want to do with to try to foster innovation. And that is helping small startups be able to afford to hire a really high quality workers. And this is going back to whether it be by helping them have affordable healthcare, helping them hire a workforce. Other solutions are things like net operating loss carry forward, and that is enabling startups to carry that loss over their taxes. I mean, there's a lot of solutions that we could be implementing that help foster the startup and the innovation community, instead of saying, look, we got to keep the tall guy down. How about let's help the little guy lift up and create some competition for them. And that's where I'm a strong believer in. And I think that's what we need to focus on, not putting more rules and regulations. And even more offensively, I find that creating a bigger federal government, just not the answer to what George Washington called our 50 states, or at the time the colonial states, that it was the greatest experiment in the world. And that is that, you want 50 states to be able to develop different policies, procedures, and then we all learn from the best. So it needs to start at the levels that help entrepreneurship up, not keep the big guys down.
Agree completely. Sam, did you want to weigh in on that? I noticed that you had unmuted yourself.
Yeah, although I wish I could weigh in on the basketball analogy, but I'm sure I have a colleague who I think would definitely have a few things to say. But one thing I think we definitely should talk about is data, and is the importance of data. And I think that it's very easy to overstate the importance of data, to kind of treat it as if, I hate this expression, data is the new oil, which is really kind of banal and kind of vacuous, which kind of misunderstands the way data is used. But I think that we have to acknowledge that there is some value, and there can be some value to data for tech companies. And this gets to a sort of often I think fundamental trade-off between privacy regulation and privacy as consumers want it, and innovation and competition. To the extent that data can be used by businesses to, for example, target advertising or refine their products, the more privacy regulations control in a very blunt way how easy it is to transact data and trade data, the more they embed this sort of incumbent advantages that the Googles and the Facebooks of this world have, because it's very easy for them to collect data. And I think it's a good thing for them to collect data, because I think it improves their product offerings, and I think it makes advertising more relevant and cheaper for businesses and so on. That's great. But privacy regulations mean that it can be very difficult for would-be competitors to get access to similar kinds of data, which they would be able to if it weren't for those regulations. So I don't think that means that we should throw out privacy. I don't think that means that we should not value privacy at all, because clearly that is something that many people value to a great deal. But I think it means we need to be a bit smarter about how we regulate privacy, and to think about, how important is data in terms of how long lasting it is? How important is data in terms of, if there is a data breach, does this permanently change my life? My genetic code being released probably would. So that's very important to not allow to be kind of traded easily. But, the place I was 2 weeks ago, or a website that I almost bought some coffee at 2 days ago, that's probably less important to my life. And so if we can think about, what are the benefits of allowing that kind of data to be transacted compared to what are the costs to people of the worst happening and that data falling into the wrong hands, then I think we could come up with a much more sort of nuanced and hopefully more pro-competitive approach to data privacy regulation.
Absolutely. Karen, did you have any thoughts on that?
Well, only this. Obviously, we're very concerned about 50 states doing their own thing on privacy. The impact on small businesses, having to comply, with all these states' various, regulatory schemes and frameworks, would just be impossible. Obviously, we don't want the California standard. And we do think there is a role, for the federal government to play in having one standard. And we hope it's, as Sam outlined, a very reasonable one where, there is the value that we see, we use the value in data, and that's balanced against, true protective measures for consumers that they have a role in opting in, opting out. So that is our big concern about that right now is just, boy, if we had, and it's moving, we've got states moving on their own. And if you're a small business, you're on, well, a lot of them are, they found a national marketplace now, right? In the COVID-19 economy, and having to comply with a variety of different states, boy, that's going to be very, very burdensome and very, very difficult. And, the liability that they're open to is just going to be extraordinary. So this is something that Congress really has to move on.
Absolutely. Representative, do you have thoughts?
Yeah. I mean, I guess I didn't mean to imply that 50 states should have 50 different rules on this. I mean, there is a role for federal government without a doubt. But I think, having more federal government and adding more rules is just not the answer. The right ones matter is, I think, what, Karen had said is it's the right rules.
Muted. Representative Gaydos, we totally agree with that. I mean, there's a role in the federal government, when it comes to, interstate commerce and these types of things. But certainly we think it's very important for state competition on tax and regulatory workers, all those other things. I mean, we see that happening now in the states, right? The massive movement of people to these pro-business, low-cost states, where the taxes are low and the living is pretty good. So we are big on state competition as well, but there are these certain things. So we're in total agreement, Representative Gaydos.
Excellent. Well, we're coming up on 1:30, which is our official end time. I really want to thank all of you for this vibrant discussion about competition, innovation, entrepreneurship. And just wanted to give the floor over to each of you for any closing thoughts or remarks that you may have. Again, I really appreciate you joining us. I thank everyone in the audience for watching.
I'll go first since I spoke first. Since we're at Americans for Tax Reform, it would be negligent for me to not discuss tax briefly. And I think that one way of thinking about a lot of the proposed interventions is as a kind of stealth tax. In Australia, for example, the competition authority was given the responsibility of basically forcing Google and Facebook to pay the big legacy news publishers for people linking to their content. Now, we can talk all day about what we should do about news content. We could talk all day about whether it's appropriate for government to try to support certain forms of news content. But it's very clear to me that what the Australian government, through the Competition Authority, was trying to do was redistribute from, effectively impose a tax on these two tech companies in order to transfer it to, in Australia, very politically influential publishers. I think that across the economy, especially around tech, lots and lots of the antitrust interventions are in many ways best understood as that kind of stealth tax, kind of an off-balance sheet tax, with all of the inefficiencies and all of the, I think, challenges to the rule of law that kind of approach would suggest. So if you're watching and we haven't convinced you that antitrust matters because of the rule of law, if you think about it as a kind of stealth tax, a tax in disguise on basically the most successful companies in their respective sectors, it might be a way of understanding why this is so challenging to productivity and kind of enduring economic growth.
Excellent. Thank you, Sam.
Yes, and Tom, let me thank you again for having SBE Council, and again, congratulations on the launch of the center. Look forward to working with you. I guess my final word would be that it's more important than ever that, elected officials, Republicans and Democrats alike, really understand the value of technology platforms and the role that they're playing in small business growth, success, startups. I mean, just the entire ecosystem. And particularly now during the pandemic, and we're still closed in many states and in many localities, but we're at a different place now. And we know that there's a lot of comfort in the online world. Things are going to continue to evolve and change as we move to a 5G environment. So I think many small businesses, sort of being forced into this a new digital world has been very good, because there will be continuous changes given what we see as new technologies in the pipeline. That is, if they're allowed to come to market, if the government doesn't mess it up first. But, small businesses have more options than ever to reach customers. And it's a very dynamic, continuously evolving, the retail industry is very dynamic and continuously evolving. And those options are going to continue to grow. And I encourage people just, visit our website, sbecouncil.org. We have lots of new papers that have just come out sort of on antitrust in small business, technology in small business, big tech in small business. And we'd love to hear, from small business owners to give us their story that we could share if they want to become engaged in our efforts. Because we think entrepreneurs and small business owners are really good messengers on this very critical issue for our country.
Excellent. Thank you. Representative, want to close this out?
Sure. Well, I think Sam and Karen really, closed it out really nicely. I would add actually one other thing, and that is that, prior to holding office, I ran my own company for 25 years. I think we just don't have enough people in Congress that have those experiences. We started in the House, I and two other freshmen, when we started the Economic Growth Caucus, which the criteria was you had to have signed the front of a paycheck and you had to actually had a significant payroll. And what's nice is that when those of us do get in the room, we have conversations that kind of really focus on less on a learning curve and more on problem solving and saying, how do we get to the end goal? So anyone who's on this call who is an entrepreneur listening, I would implore you to seek to try to maybe run for office and so that we get more pro-business entrepreneurs who have had those experiences within Congress, within the state legislatures, or with even your local government. And I think that will really help in many ways. And I just wish that more people would understand both sides of both being a legislator and also of being an entrepreneur, because there are some challenges being in the being a legislator. It's public service, so everything can't be purely entrepreneurial. So that's just my last statement on that, is that we need more entrepreneurial thinking to be problem solvers.
Excellent. Well, thank all of you for participating in this panel. Thanks to the audience for tuning in and for supporting our work. You can find us again at opencompetitioncenter.org. And we look forward to working with each and every one of you to promote innovation and competition. Well, thank you, and we'll chat soon.
Thanks.